All right, good afternoon, everybody. Thank you very much for attending. Thank you for being here. We know that it was short notice, but it's a tribute to the university, to the law school, to the city of Berkeley that we can get an auditorium well filled with 24 hours notice, so thanks for being here. Just to give you a sense of how the program will proceed, Mr. Nader will speak for half an hour, 45 minutes, half an hour, 40 minutes, and then he will take your questions in the fireside format to my right. Please, if you would, write your questions down on the cards that either I think they have been provided to you. If not, raise your hand and one of the attentive card providers will provide you with a card, and then they will be passed up, and I will present them during the discussion part of our program. But let me introduce then our program and our speaker. My name is Ted Merman. I am the executive director of the new Center for Consumer Law and Economic Justice here at the Berkeley Law School. The center is dedicated to the advancement of consumer law within the legal academy, to the training and the mentoring of law students, and to the furtherance of the cause of consumer rights and economic justice in the courts and the legislatures of this state and of this country. The center, I should mention, I'm the interim executive director. The center is so new that it doesn't exist yet. It will exist as of April. I'd say as of April 2nd, to avoid any implications of saying anything earlier than that. But we have been brought out of our pre-existence by the remarkable opportunity to host a man who I would call the preeminent consumer advocate of the past half century. As you all know and are aware, this is National Consumer Protection Week. I know you've planned your week around this. Here to celebrate the week and the birth of the Consumer Law Center is, as I've said, one of the true giants of consumer law. You ask, I can hear it, what has Ralph Nader done for consumer law? Let me just give you a small taste. He's the founder of, we'll say, several nonprofit organizations that are dedicated to the cause. Public Citizen, Public Justice, the PIRGs, the Public Interest Research Groups, Congress Watch, the Center for Science in the Public Interest, the appropriately named Appleseed Foundation, if we have a modern-day Johnny Appleseed, he's standing here to my right, and 50 more. I'm trying to found one, and it's enough of a challenge. He has been instrumental in the passage of landmark laws that we all benefit from: the Consumer Product Safety Act, the Clean Air Act, the Clean Water Act, the Foreign Corrupt Practices Act, the Freedom of Information Act, the Truth in Lending Act, the Fair Credit Reporting Act, the Equal Credit Opportunity Act, and I could go on. And he has, because that wasn't enough, created entire federal agencies with others, but certainly with his own advocacy: the Environmental Protection Agency, the Consumer Product Safety Commission, the OSHA, the National Highway Traffic Safety Administration. By comparison, we give Elizabeth Warren a lot of credit for one. In the past 50 years, just to take one of those examples, NHTSA, the National Highway Traffic Safety Administration, the design standards and recalls and general auto safety-related measures have reduced the rate of deaths per mile driven by nearly 80%, which has saved, according to an analysis by the Center for Auto Safety, more than 3.5 million lives. As The Nation put it recently, and I'll quote this, "And so, the modern consumer movement was born with one man's strategic decision to hire over time thousands of raiders, Nader's raiders, not the guys, the silver and black ones down the road, to work more on cars and nuclear power, pipeline safety, food and drug safety, airline safety, water and air pollution, antitrust enforcement, corporate governance and shareholder democracy, clean energy, tax reform, income and wealth inequality, campaign finance reform, pension rights, old age homes, occupational hazards, healthcare, smoking, freedom of information laws, multinationals, the educational testing service, Veterans Affairs, land management, whistleblowing, trade policy, insurance, procurement, a seemingly endless list of vital issues with profound real-world consequences. And the article concludes, if there had been no Ralph Nader, there probably would not have been a consumer rights and corporate accountability movement, or at least nothing remotely resembling the hundreds of organizations, laws, and books that have sprung from his initiatives. No living American is responsible for more concrete improvements in our society. Ladies and gentlemen, Mr. Ralph Nader.
Thank you very much, Ted, and ladies and gentlemen. Obviously, I want you to remember this hour, and so I'm going to have to try to produce some deep imprint assertions and declarations and distinctions because the legal system is in very serious crisis, far worse than during the McCarthy period in 1950s. And you can pick your sector and your area, and our profession is just not up to it, and our law schools are not up to it, although they could be. And so we pay attention to this gap. Let me just ask you, how many 1Ls are here? Okay, and how many 2Ls? 3Ls? Okay, that's not bad. Usually the 1Ls predominate. The 2Ls get a little bit skeptical. The 3Ls can't wait to get out, and they're cynical. And so you get, they come in idealistic, and there have been studies about this. And by the time they're out, they're very pragmatic. Student loans make them even more pragmatic, and they go for the corporate law firms. So when I was a law student, I want to give you a little perspective because you can see that a lot of the changes that have been made compared to what was the situation when I was in law school were due to students. Student demands, student sit-ins, student protests, pickets, you name it. And they often had some brave faculty with them, but the propulsion did not come from the top of the law school. So here I am, I'm a first-year law student in the 1950s, and I look around, there are 550 students and 15 women, maybe a couple African Americans, no Hispanics. And Harvard Law School introduced its first woman student in 1950. Now, this was considered a preeminent law school in the country. They had the best and the brightest law professors. If you didn't believe it, all you had to do was ask them. And yet they were so myopic that they thought that was the natural order of things, that this was a white male province. They weren't going to get married and have babies. Why waste a seat with a female student? And as far as the minorities go, they would admit any qualified minority as long as they had high SAT and LSAT scores, which of course were systemically rigged against low-income students to begin with. So that was the rough cut scene. The curriculum was shaped in order to enhance the commercial job prospects of the law students. So, for example, we had a lot of courses and seminars on securities law, property, taxation, bankruptcy, you name it. We didn't have a consumer law course. We had one clinic. There are now 30 at Harvard. We didn't have anything on corporate crime. As if there wasn't a corporate crime wave. We had a course called landlord-tenant. I don't recall us ever getting to the tenant. Harvard law graduates are going to mess around with tenants. The money's with the landlords. And you can see it skewed that way. Again, the professors never talked about it. It was like it was the natural order of things. The natural order of things. We had a contracts course that hardly mentioned adhesion contracts. It was all negotiated contracts because that's where the business is, in the law firms. We were supposed to be critical of everything, including the opinions of learned hand, except we weren't supposed to be critical or know much about the dark side of corporate law firms who came to recruit us, because that would upset the equilibrium between the law schools and the law firms that provided them with contributions and material for the professoriate and other links. The jokes were designed to acculturate ourselves into the profession. One professor once joked that at Harvard Law School in the morning we contract the law of torts, and in the afternoon we distort the law of contracts. We all laughed knowingly. Inside joke, right? And what's happened in the last 50 years? That's exactly what's happened. We've lost our freedom of contract with contracts of adhesion more than ever, and tort law is being shredded by what is euphemistically called the tort reform movement of the insurance and other industries, so that they are not exposed to accountability in an open law, open courtroom with a trial by jury. So now you wonder why we're in such trouble when we've graduated generations of law students so unknowing, so fact-deprived, so skewed to represent vendors, not consumers, to represent giant employers, not workers, to represent polluters, not forces of anti-pollution, to represent the power structure, not the people who should be the leading beneficiaries of the compassion of the law, which, if it doesn't spell justice, has lost its raison d'etre. Years later, the Chicago School of Law and Economics started spreading throughout the law schools an empirically starved ideology filled with hubris and arrogance, to a point where, and this is a very important human development, most of you have probably heard of Judge Richard Posner, Circuit Court, right? He's written 40 books, thousands of opinions, Harvard Law grad, considered very brilliant, and year after year he would espouse the monetization of legal justice, the marginal utilities in dollar terms. He was a leading architect of the Chicago Law and Economics School. And one day he came into class, he would teach a class at the University of Chicago Law School. This is an eyewitness account from a student. He walked up to the blackboard and he wrote the word justice across the blackboard. And he said to the students, "You see that word?" And they all said, "Yes, sir." So this is the last time I ever want to hear that word in my course. That's the Chicago School of Law and Economics. Justice was considered soft, normative, not precise, not quantitative, not discernibly rigorous. It was also considered inconvenient in terms of the legal hierarchy and the power structure. A year ago, almost a year ago, Justice Posner resigned from the Court of Appeals with an amazing declaration written up in the New York Times by Adam Liptak. He said that after seeing more than his quota of impecunious defendants charged with criminal offenses, poorly represented and driven into imprisonment by a legal system that was discriminatory, he was going to devote the rest of his life to trying to do something about it. The lesson is, whenever you hear people talk about smarts and brilliance and high IQs, they can be also massively insensitive and myopic. At least he's trying to redeem himself, unlike many of his peers in the Chicago School, whose influence, fortunately, has started to wane. So here's what it was like at the law school. I'd write a long article for the Harvard Law Record newspaper on the Commonwealth status of Puerto Rico, and I'd walk down the corridors between the school buildings, and the students say, "Why are you wasting your time on that subject?" I'd write a long article after visiting the Indian reservations out west, American Indians, people without a future, and they said, "You know, you're supposed to be studying. You're supposed to be working to get on law review. What are you wasting your time with this for?" It got worse. I wrote an article that there were 11 states in the 1950s that prohibited women from serving on juries. Do you know that? 1950s, including Maryland. Didn't create a stir. Today, obviously, it'd be an uproar. This is what happens when over-specialized minds become narcissistically monetized and they don't look at the big picture. And that's why I spent so much of my time on the Harvard Law Record newspaper. It's the oldest law school newspaper, 1946, that went out to 10,000 Harvard Law School alumni and was the second largest circulation paper of any legal publication in the country after the American Bar Association Journal. So my first recommendation, if you don't have a law newspaper, start a law school newspaper. Make sure it's in print as well as online. It doesn't take more than 3 or 4 students to pull it off, to put out maybe 12 issues a year. That's where you're going to be able to deal with the law writ large. That's where you're going to be able to deal with foresight, with expectation levels, with the dark side of the law, with the specter of mass lawlessness by the rich and powerful, with the phenomena that you don't find in the law review. I could never accuse Harvard Law School of foresight because you couldn't footnote it. That's how narrow things were. If you couldn't footnote it, why was it worth reading? What about imagination? What about vision? What about expectation level? What about idealism? What about justice? All those were considered intellectually soft. Empty, not rigorous like X10b5 of the Securities Code, or the intricacies of corporate taxation, or property law, or bankruptcy law. A massive form of brainwashing, and most of us fell for it. Luckily, I didn't fall for it, because I had a lucky choice of parents who made me see things that were in plain sight. Like, why weren't there corporate crime courses? Why wasn't the consumer part of the Harvard Law School curriculum? Why weren't there clinical trial opportunities? Why didn't we ever talk about legal history, even though it was critical to understanding our profession? Why didn't we ever talk about the difference between attorney and lawyer? Have you ever had a discussion of that in law school here? We never did. Do you know what the difference is? When you are licensed to practice law, you're considered an attorney at law. You have the legal right, as part of a monopoly, to attorn for your client zealously. But what we're not told is because the canons of ethics impose another obligation on us as lawyers, without clients, to look out for the administration of justice and the distribution of justice in our society, and to make sure institutions arise that are representing the unrepresented, and to build structures of reform. That is part of our code of ethics. And we don't study that at law school. I remember in the contracts book and the property book, I desperately searched among the 19th and 18th century cases for cases on slavery. They were very highly litigated, you know, for contractual and property rights purposes. But West Publishing kept those cases out of the case book because they wanted to sell their books to Southern law schools. What you don't see, you don't think about. You don't read about the cases where contractual disputes and property right disputes involved the separation of children from their parents and husbands from their wives in the auctions of Charleston, South Carolina, and the slave marketplaces. There's another issue that is never discussed. Law schools love to say they have legal aid and they have clinics. That's an important source of charity. Legal charity is important. It sensitizes you, it puts your feet on the ground, you meet with real live human beings who are aggrieved and unjustly put upon. But if they don't draw the distinction between charity and justice, they will never lead you into structural reform and preventive law. You'll be working on soup kitchens instead of a political economy where people should never have to go to soup kitchens because they earn a decent livelihood. That's the difference between charity, and legal justice. There's other aspects which I won't go into. But then you say, how about today? Okay, we have diversity. And what diversity does, unquestionably, is it gives whole sectors of our population an opportunity for upward mobility according to their talents and energy, merits, not color, gender, etc. But then you ask the next question. It's all about asking sequential questions. Mobility upwardly for what? To go into male-dominated corporate law firms and get the cues that if you don't mimic them, you don't advance? Try to break the mold, bust up the routine, change the allocation of representational resources. You don't get anywhere. You get along by going along. Have things changed because there are more women, African Americans, Hispanic Americans, LGBT in the legal system? Yes. But how much? Have the real structures of power, military, foreign policy, presidential lawlessness, the corporate state, crony capitalism, the corporate supremacist over workers, consumers, communities, corporate globalization, corporatized technology, massive manipulation of people through contract adhesion, exclusion of people from their right to their day in court, irrespective of race, color, creed, gender, sexual choice, etc. How much? Well, some has changed at the grassroots level. There's been some change due to the diversity. But corporations protected by corporate lawyers are brilliant adjusters. They will adjust, they'll step back one, they'll go forward one, then they'll pull it back three, and before you know it, the diverse population inside the legal profession in the next generation, when it loses some of its fervor and forgets where it's coming from and who made it possible in the prior generation, they get assimilated. And so the issue of corporate supremacy, the corporatization of just about everything, the giant corporate strategic planning of our electoral system, our political system, our military and foreign policy, our technologies, the strategic planning of our genetic inheritance, of our educational system, of our consumer levels of incarceration with the credit debit payment systems economy, of our environmental processes, sometimes impeded, sometimes challenged with a successful case here and there, but the unerring trajectory is to subsume the human beings under we the people and the Constitution to the supremacy of corporate state power, the blend of big business and big government designed to serve big business and turn against the very people who have delegated powers to the Republican form of government. Where are the law schools? In Washington now, we're in the middle of the Trumpster dump. We're in the middle not just of a president who's illiterate, who is a bigot, who is a misogynist, who is a corporate cheater, who is a prevaricator, who is, you pick your adjective, but who is a brilliant distractor from the next stage of corporate statism and the militarization and the policization of our public life and foreign policy. What has happened to the law, which is designed to discipline power, is its promoters and protectors and practitioners have not gone to the level of stringency to shield them from being corroded, destroyed, or manipulated by raw power. The tensions between the rule of law and the rule of raw power. Political power, economic power, corporate power, technological power, you name it. But it's driven by commercial values. Commercial values arrayed against civil values have been going on for centuries. Every major religion warned its adherents not to give too much power to the mercantile class for exactly the reasons then that apply today. A monistic-driven focus on maximizing profits and the riches of the ruling class, colliding with all other value systems, overriding them, depleting them, destroying them, marginalizing them, co-opting them, as the case may be. From time to time, this is challenged. It's challenged by the environmental movement, the civil rights movement, the women's movement, the consumer movement. They don't have the stamina that the commercially driven corporate movement has for obvious reasons. It's singular, driven, and wedded together, and never gives up. It's part of the DNA of the frailty of human beings. And because injustice operates 7 days a week, the forces of justice have to be capable of rising to that challenge. And so what is the deployment of lawyers in our country? The usual estimate is that 80% of the lawyers represent 20% of the people. Maybe it's 90% now representing 10% of the people. The myths of equal justice under law, access to justice, are just that. And so about a year ago, I wrote a column entitled Harvard Lawless School. And I suggested that because in the theater of the rich and powerful, both in government and in the corporate world, the specter of lawlessness is systemic. It's the norm. That the curriculum at Harvard Law School should be split, and the students should choose. They want to go to Harvard Law School, they can study the law, the statutes, the regulations, judicial decisions. They can pick them apart, suggest improvements, try to interpret them, try to find out how they are interpreted, develop with the transactional nature of the routine legal system. Other students can choose to go to Harvard Lawless curriculum and study lawlessness as a systemic discipline. Lawlessness zones come in many ways. We now have a massive lawless zone surrounding the presidency. You have one of the nation's experts here on your faculty to teach you how to have a lawless presidency. John Yoo. For John Yoo and his colleagues, there is no constitution or statute that cannot be bent in the service of raw power. Presidential power now, with the help of the aiders and abettors in the Office of Legal Counsel and the Justice Department, under Clinton, under George W. Bush, under Obama, under Donald Trump, is essentially, when veered outward, boundaryless. The president, as commander-in-chief, can now do anything he wants to do in the name of national security. He has been allowed by a supine Congress, violating its oath of office to uphold the Constitution, including the Declaration of War authority. He has been permitted in his reckless, boundaryless power plays by a judiciary with its artifices of a political question or no standing to sue, with arbitrary, limitless expansion in its interpretation, to do whatever he wants abroad as prosecutor, judge, jury, executioner, and cover-upper. It was Obama who basically said, in his lone judgment, he could kill any American citizen overseas. Due process? Laughably. That's where we're at now. When it comes to the armed forces of the U.S. empire, there are no such things as national sovereignties in the third world. Drones, special forces, can and will go anywhere in the pursuit of national security. Imminent threats have been diluted to thousands of miles away. Articulated verbally, it didn't matter. Is this shaking up the law schools? Has this shaken up the Harvard Law Review? Has this led to demonstrations? Has it affected the small talk between law students, going back and forth between classes? Has it led to a break of routine? Maybe in a few cases. We hear from students once in a while. But the norm behavior is on the road to complicity, on the road to aiding and abetting, on the road to shoehorn lawlessness, criminal wars of aggression, corporate crime waves, misuse of taxpayer funds, violation of fiduciary responsibilities, and on and on. You ask yourself, you want to work for corporate law firms, you're entitled to find out what you're getting yourself into. Back in the 60s and 70s, some recent law graduates could opt out of representing the tobacco industry in Covington and Burley, but they weren't about to make partner any time in 7 years. Now it's more difficult than ever to opt out in terms of an act of conscience with these gigantic law firms. There are law firms in this country that have more lawyers than the entire number of attorneys in the Justice Department's civil rights and criminal environmental law divisions. Just one law firm. Talk about the deployment of lawyers. Now I want to read you, just so you don't think you're hearing outlier type expressions, a statement from the American Bar Association Model Rules of Professional Conduct. Can't get more establishment, right? This is a corporate-dominated bar association. Just go to their meetings. Here's what the ABA Model Rules of Professional Conduct said about the privileges of being a member of the bar. Short paragraph. I quote, "A lawyer is a representative of clients, an officer of the legal system, and a public citizen having special responsibilities for the quality of justice. As a public citizen, a lawyer should seek improvement of the law, the administration of justice. A lawyer should be mindful of deficiencies in the administration of justice." End quote. What percentage of an attorney's time in this country do you think is allocated to that declared mission? Not 1%. Which is why a third-year law student named Pete Davis at Harvard decided to take hundreds of hours of his time between his 2L and 3L tenure and put out this report called Our Bicentennial Crisis, a call to action for Harvard Law School's public interest mission. How many of you heard of this? Okay. This was sent to every dean of every law school. We got one response, 205 deans. Is there an intellectual life on campus outside your coursework? Now let me tell you what's in this, because it applies to you and all law schools. The first part, he quotes the Harvard Law School's declared mission. I kid you not, this is not a joke. Here's Harvard Law School's declared mission. Quote, "To educate leaders who contribute to the advancement of justice and the well-being of society." End quote. Are you serious, Harvard Law School? You have contributed corporate crooks, running crooked banks and brokerage firms. You've contributed corporate senior partners who facilitate in ways that aren't exactly ethical, destruction of documents, etc. Facilitate corporate crime, create the architects for it. Look at the Wells Fargo. You don't think the lawyers for Wells Fargo knew that 3 million customers were being sold auto insurance and millions of others were being imposed upon with new credit card accounts without their knowledge and permission? Do you really think the architects of Wall Street firms didn't know what was coming and what was going on before the crash in 2008 that took 8 million jobs, threw country in a deep recession, shredded trillions of dollars of mutual and pension fund money, didn't lead to one prosecution attempt by the Justice Department, and then was bailed out by the taxpayer? The Secretary of the Treasury at the time, Secretary Paulson, was former chairman of Goldman Sachs, came away with $650 million, became Secretary of the Treasury under George W. Bush. You know what he admitted to the Washington Post, page 1? He bailed out Wall Street. Here's what he said. "I knew I didn't have the authorities to do what I did, but somebody had to do it." Those were his quotes. Do you realize the magnitude of that admission? He didn't have the authority to bail out Citigroup, Bank of America, Merrill Lynch, the various banks out west. But someone had to do it. And Congress let him do it. And there wasn't a tremor through 1.3 million lawyers of our land, or a shockwave through 200 law schools, with few exceptions. All right, here's what he covered. He's one of you. Okay? He's 26 years old. He starts out with Oliver Wendell Holmes' challenge. Imagine law students reading Oliver Wendell Holmes. Quite interesting. Here's what he said. I'll be very brief. This is a call to action. The crisis of our time, mass exclusion from legal power. Who's being excluded from legal power? The vast majority of the American people who desperately need lawyers. Legal aid is starved. Public defenders are starved. In Florida, they're paid $45,000 a year. Public defender. You can imagine the caseload. Furthermore, Legal Services Corporation is desired to be phased out and closed down by the Trump budget. It's not going to happen. Some corporate lawyers have risen to the occasion and are opposing it, but at least imagine the brazen attempt to shut it down. Then he says Harvard Law students' failure to lead. He gives all the excuses that law school administrators give. Well, everybody deserves a lawyer. Graduates take public interest jobs later after they pay their loans. Students are free to choose their careers. This involves factors beyond Harvard Law School's control. And Harvard Law is a path to the upper class. You got any objections to that? And Harvard Law School through the eyes of the poor. And then he goes on and he discovers an amazing statistic. More Harvard Law School grads go to work in corporate law firms in New York City than all the Harvard Law School grads who go to work in 47 other states. Think of the mission of the Harvard Law School to that kind of default option. Then he has a reform of the curriculum, and then he reforms the cost structure, and then he ends it with our bicentennial choice. I'll leave this in your library for you to peruse. So quickly, before we get to our discussion, here's what I asked when I was a law student. What is it we never discuss, we never get taught about, and we don't even have extracurricular activity to deal with? That's a question you should ask yourself today. You'll be surprised by the proliferation of areas that fit those categories. The second is, why is it a law school can take an aider and abetter of criminal wars of aggression and give him a titled chair and professorship? I'm talking about John Yoo. Don't think this is just freedom of speech. And another plaintiff lawyer, one of the leading class action lawyers that has redistributed billions of dollars from corporate crooks to their consumer and shareholder victims, William Lirac, who was slated after he got out of jail, I'll get to that in a moment, to give a course here, ready to give a course. Nobody knows about corporate crime like Bill Lirac. And he was excluded by whoever upstairs or in the alumni learned about it. What was Lirac's crime compared to aiding and abetting criminal wars of aggression that killed over 1 million Iraqis, sociocided that whole country, thousands of refugees, dead babies, pulverized public services from health to street security, without being declared as a war, continuing on to the present day, saying it was part of presidential power? How can Bill Lirac's crimes compare? You know what he was charged with? There's a doctrine of the lead plaintiff. Whoever gets the lead plaintiff recognized by judges among the plaintiff lawyers has an outsized role in the strategy and the remuneration of the class action with lesser plaintiff lawyers. And he was charged with paying professional plaintiffs to be lead plaintiffs. That's a significant violation of legal ethics. But does it warrant several years in jail compared to the crimes of corporate lawyers who are given the title senior partners of prestigious white glove law firms? Does anybody know the dirty tricks they play? that are outright criminal violations. So he serves his time honorably. He's a good prisoner. He gets out, and he's about to teach a course here, and he's excluded. That's the difference. Depends what structures you serve. Finally, we have a book in your library called No Contest: Corporate Lawyers and the Perversion of Justice in America. I suggest those of you who want to go to work for corporations and corporate lawyers leaf through it to see what you're getting into and to see what happens to you when you're not allowed to take your conscience to work, when you are a secondary human being in service of your corporate client zealously, when you are not a primary human being, when you are a tradesperson, not a professional person. The difference between a trade and a profession is that a profession is a learned discipline with a tradition of public service and a tradition of independence, the last two being surrendered to the incarceration of the legal profession by the corporate supremacist in return for very lucrative client remuneration. Just think of that. Think of what you're going to look back on 15, 16,000 days from now when you retire. Perhaps you'll have more bionic equipment in your body and you can go 20,000 days. And you look back and you see that you missed the train of justice, that you were representing perpetrators of injustice, not the aggrieved, not the innocent, not the victims. And that you were rationalizing it by saying, everybody deserves a lawyer. Yes, indeed. ExxonMobil, General Motors, Pfizer, Kennecott Copper, Prudential Insurance, they all deserve lawyers. But they don't have to deserve you, because they'll always be able to have lawyers. It's not like saying you're representing the poor because everybody poor deserves lawyers. There's a different marketplace operating here. The great lawyers are those who have great expectations of themselves, who stretch their potential for justice, which Senator Daniel Webster once called the great work of human beings on earth. For without justice, there is no freedom and there is no liberty. And human possibilities are severely restricted. I commend the new Consumer Law Center. They're going to do great things. You're going to do great things. Your work can reverberate throughout the land to be an example for other law students. You can upend the contracts of adhesion and the contract peonage and servitude that encircles hundreds of millions of people in this country. You can strengthen the law of torts and prevent the law of contracts of adhesion from cannibalizing the law of torts and taking away their right to open court and trial by jury. Because you are the conscience of the profession. You understand that? The corporate lawyers cannot look you in the eye when you challenge them, because you're not showing them dollar signs in your eye. You're their conscience. I've seen it happen in the past. You can stare them down if you want to make sure that you're going to be a lawyer as well as an attorney in the advancement of justice in our country. And if you need a reference point, go back to what the law students did in the 60s and in the early 70s, in the civil rights, women's rights, aid to the poor, environmental movements. and how they rated the law firms that came to recruit them on pro bono basis. And they talked to the law firms and said, what are your pro bono policies? What are your conflict of interest policies? What are your subtle penalties for people who join you and don't want to represent the vile clients that have caused hundreds of thousands of deaths by deception and child molestation, like the tobacco industry? And see what they did. See how an editor of your law review, Michael Tiger, would have national press conferences with articles in your law review because he thought the public had a right to know what the law review was revealing. If you don't think high enough of your own significance and you become a technician, you become the harborer of low expectations, the corporate law firms will oblige you. The world's problems are not going to be treated or solved by corporate law firms. They're far more likely to be created, exacerbated, and institutionalized by the nefarious brilliance of these corporate lawyers. It's your choice. Thank you.
So for those who can remain, thank you very much. If you have written questions, please do pass them to the aisle. Some of you have written questions. Terrific. And we will we'll move on to the fireside part of our chat here. And we'll get right to it. But if you have further questions, yes, just raise your hand. And let me just very briefly say thank you to the events team that put this together in less than 24 hours. All behind the scenes and just fantastic, and without them, this kind of thing wouldn't happen. Okay, question for you.
Okay.
Hi, I'm a student activist with the CalPIRG chapter at UC Berkeley. Student PIRGs helped create the Consumer Financial Protection Bureau a few years ago, and we know that it's being attacked at the federal level. What is the future, or what might the future of the CFPB be, and how can we work to protect it?
See, this is where we want the brains of law schools. You have heads of the EPA and the CFPB who have openly said, Scott Pruitt, Michael Mulvaney, that they want to dismantle the agency. They make no bones about it. They are shutting down enforcement cases in the pipeline, pulling back lawyers from courts, intimidating civil servants and violating their civil rights, rolling back regulations, and aborting any regulations that are under proposals under the Administrative Procedure Act. Okay, so I asked the lawyers in Washington, the public, come up with remedies. Come up with equitable remedies. For heaven's sake, make sure you take a legal history course here on equitable remedies, if you have an equitable remedies course. Are there judicial mandates that can go up against Scott Pruitt? He's violating his oath of office. Now, there is such a thing as prosecutorial discretion, huge, but there are limits to it, aren't there? If you have a police precinct chief who basically says, I have limited number of police, I can't go after all the street criminals, and here are my priorities. That's okay. They get away with that. What if the police chief said, I want to cut the number of police down, and I know there's a corporate crime wave out there, although I don't think it's very serious, and I don't want to enforce the laws. There would be a legal action against that police chief. Well, take the federal cop on the corporate crime beat. Where are the remedies? I don't know where the remedies are. We're not talking about APA lawsuits filed by NRDC. They're all underway. Arbitrary, capricious, standard. We're talking about in personam punishment and removal, short of impeachment, which is another alternative. Officials can be impeached who aren't in the presidency. And we're waiting. We're waiting for creative legal arguments under equitable law traditions, maybe going back to medieval England, to go after these people. You cannot believe how brazen they are. There's no hiding it. They've done it, and the curve is going to be more intensive in the next coming months because they're learning how to do it.
I'm not sure that counts as a solution.
No, basically he's shutting down the CFPB. In fact, he has stated, I am going to defang the CFPB. And you've got a Wall Street crook saying, whoa, terrific, Mike. So he's admitted it. Now, what are the boundaries? The law is nothing if it isn't something that provides boundaries. There has to be a boundary beyond prosecutorial discretion. He's literally cutting the budget. His budget request for the first quarter, 0. Isn't that actionable? He's taking the federal cop off the corporate crime beat. So, can't we rely on law schools to come up with something? Law professors? I'm sure. Maybe we're not aware of what's going on. That's why we need a consumer law center.
Absolutely. Let me ask another question near and dear to the hearts of many in this room. How do you suggest students with $150,000 of student debt from law school and who need to pay it back find a career in consumer protection?
First, you go to work for a corporate law firm, pay it off. You've been inside the belly of the beast. You'll be able to use that knowledge very usefully. And now the question is, you want to do what you really want to do, and where are the jobs? We organized our law school class of 1958 to start the Appleseed Foundation, and they have opened 16 centers for law and justice in 16 states. They probably have 50 jobs, maybe 70 jobs, just one law school class. Now, what if all kinds of alumni classes from law schools around the country, 40 years out, 35 years out, thinking about moving from success to significance, do the similar thing? They have an obligation to create positions for you. They can't just tell you, come on, drop your corporate law cudgels and start fighting for the people. The other thing is through consumer checkoffs. When we established the Citizen Utility Board statute in Wisconsin, Illinois, San Diego, consumers opened their utility envelope and out fell a little card. Said, do you want to join your own consumer group with your own lawyers and economists, etc., to fight the utilities when they try to gouge you or deny service or whatever? That created jobs. So you have the whole facility ideas is another one. The third is you begin taxing the corporations who are using our commons free. Okay? So you say, why are you using our public lands? Why are, you mine for gold and you don't pay any royalties on the gold found on public lands? Why isn't there a sales tax on Wall Street transactions? You pay a 10% sales tax here. Someone tomorrow buys $100 million of ExxonMobil derivatives, 0 sales tax. You can have a sales tax, which we used to have years ago on Wall Street transactions, and you reallocate the money. You start taxing broadcasters for using the public airways. That way you fund public interest law jobs. You fund audience networks. I'm leaving some material on that. I'm leaving a lot of material with Ted, so you can elaborate some of these things that you've heard if you are interested. Checkoffs, there are all kinds of ways that legal minds can develop and advocate into the future to provide the funds that provide you with opportunities to work in public interest law. My best guess is there are not more than 1,000 public interest lawyers in the country. And they don't necessarily all have to be liberal progressive. Like public interest law firms, there are some conservative ones and some more progressive ones. And the distinction is that they're not funded by corporate money, and they're not legal aid corporation. These are foundations, private donations, attorney fees type groups. You have more than 1,000. Pretty tough going, but look what they've achieved. It's spectacular what they've achieved over the last 50 years. And changing procedural rules, and environmental impact statements, and class action successes, and injunctions, and mandamuses. We challenged, for example, our public citizens litigation group challenged the shutdown of the airbag rule by the Reagan administration. We took it up to the Supreme Court. We won 9-0 to reinstall the airbag rule as standard equipment. It's because we had a nonprofit litigation group that could do that.
All right, well, Ralph, I'm going to give you a choice here. We have about 5 minutes left. Ralph has to leave for a dinner engagement. The Berkeley Law School is known, among other things, not simply for its new Consumer Law Center, but also for its dedication to and leadership in the tech space. So, we have 2 questions for you. You can answer one. Either the auto industry has moved onto the latest driverless technology. What are your thoughts on government regulations, safety guidelines, consumer rights, etc.? Or what are your thoughts on Bitcoin or cryptocurrency as a form of protection from the current corruption in banking?
Well, on autonomous vehicles, fully forget it. You're not going to see it. You'll see semi-autonomous, like brakes already, and some. The problem with autonomous vehicles is there's no defense against hacking. In fact, one of the world's expert on hacking here in California, whose clients include the Defense Department and NSA, gave a speech at Carnegie Mellon in September saying that the vulnerability of hacking is a weapon of mass destruction, that they can hack like 3 million Toyota models of similar software and drive them off cliffs or into trees. This guy knows what he's talking about. I've been to technical conferences on autonomous vehicles. The big hype, they want to appear modern. They're all trying to get press, not to be left behind. Silicon Valley companies, automobile companies. But they never discuss hacking, because that's their Achilles heel. There are other problems with autonomous vehicles. There's an article, you'll be interested in this, Ted. Harvey Rosenfield, consumer watchdog in Southern California, has delivered at GW University Law School Symposium last year on autonomous cars, 35-page brief on the consumer and autonomous cars. As far as Bitcoin, I don't know anything about Bitcoin other than it takes up a lot of electricity. You can't know things about everything. When you don't know something about it, you admit it. But I do know that it's an enormous devourer of electricity.
We are, in addition, a leading environmental law school, so thank you for that observation. The last question for you, Ralph, and this goes to most people in the room. What is the best thing a new lawyer can do to make change?
Plunge herself or himself in a legal emergency. There's plenty around. Because that gives you structure, immediacy, urgency, colleagues, purposefulness, minimum of bullshit, and internecine struggle. It's sort of like fighting a forest fire. See the unity of purpose? So get into an emergency situation. The other thing I would urge is think structurally, not just in terms of remedial treatment of individual cases of aggrieved clients. Think structurally, think justice, prevention, not just treatment and legal charity, important as that is. Third, enjoy yourself. The pursuit of justice is a pursuit of joy. It's a great way to live. You look back, you hold your head high. You see this newspaper? It's the Harvard Law Record, recent edition. I was editor of this Harvard Law Record. Without the Harvard Law Record, spearheading big issues, not law review footnote issues, the law writ large, the big policy issues, the big questions, the impertinent questions, the questions about why tort law focused on driver-to-driver combat and not automobile design or highway design. Without this paper, I wouldn't be here today. I'm going to leave it with Ted. 2 weeks ago, I sent Harvard Law students an open letter to Harvard Law students from an alumnus who wished that I had an alumnus years ago who told me what I should have known then, that I had to learn the hard way now. So you might want to read it. Go to their website, hlrecord.org, hlrecord.org. You get it all. It's all online. There should be a Berkeley Law School newspaper. How many would like to see it? How can you have a law school without a newspaper? You see, you're then restricted to your specialized courses and your clinics, but you can't unveil your wishes and your imagination and your proposals and how you see yourself for the next half century. This is what a law school newspaper can do for you. And The Bicentennial Crisis by Pete Davis is summarized in a recent issue last fall as well. You know, the dean of Harvard Law School, there have only been 3 major critiques of Harvard Law School in 30 years. This is one of them. I gave it to you.
You did?
The dean hasn't even responded. I mean, just from an intellectual point of view. Never responded. 4 intrepid law professors had a symposium with Pete Davis on February 7th at the law school. And it was an act of courage. Isn't that wonderful? What happens when you work for an institution? For a simple declaration of truth becomes an act of courage. See the self-censorship, the conformity that operates between otherwise brilliant minds? They have their own silo. Don't mess with my silo. But don't fertilize between silos. Don't look at the big picture. Don't talk of Harvard Law School as a facilitator and concentrator of corporate power in the corporate state without a peer in the country. Completely contrary to its declared mission statement of a century ago. So I'll leave these with you, and I also want to leave this. It's called Getting Steam to Overcome Corporatism. This is for law students and others who have trouble getting indignant beyond ethnic, racial, and gender slurs. I repeat, beyond ethnic, gender, and racial slurs. Getting indignant at brutal reality. Brutal reality, corporate style. Deaths, injuries, quagmires abroad, climate disruption, deoxygenation of the ocean, extinguishing of species, suppression of labor. They can't help themselves. Corporate power has to be subordinated to we the people constitutionally. The brilliant work of corporate lawyers has ensured that even though the word corporation, the word company, and the word political party are never mentioned in our Constitution, we are ruled by them. Corporations must be our servants, not our masters. They are mutating, they are innovating, they are spreading their institutional tentacles everywhere. Look at the cover of The Nation magazine, current issue. So we have over 100 excerpts of corporate abuses from the Wall Street Journal, New York Times, Washington Post, other Marxist publications, to get you steamed. And if you read through in one setting, and you don't have fire starting in your belly, even though you have a lot in your mind absorbing these factual renditions. You know what? You got a serious problem. Because without fire in your belly, your routine will not be disrupted, your career vector will not be transformed, and even though you know what's going on, you will not take your conscience to work every day, as you should, and must, and can, and blaze a trail for the generations to come after you. How many people would be in this room today if it wasn't for the law students in the 60s fighting for diversity? If it was the law students in the 50s sending the professors reeling backward who said, we can't afford to let women in because they're taking up a valuable seat at Harvard Law School, and we know when they graduate they're going to get married and have babies and not practice. We're not going to waste seats at the Harvard Law School. That's what we heard. They aced out half the human race. Now you have to stand on our shoulders, and you have the next generation standing on yours. Thank you.
Thank you. Thank you, Ralph. Thank you, sir.
Thank you. Good luck to you, Ted. Thank you.